Hi, someone from LEDX here.
Yes, hi, hi, hi. Can you
Hi.
hear me?
Yeah, good afternoon. I can hear you. I'm
Good
just joining in
afternoon.
from another device as well to share my screen for the presentation. So just give me 2 minutes as I do that.
Yeah, yeah, sure, sure. You can take like 5 minutes. We have 5 minutes.
Sure. And just to clarify, how many people are we expecting? I'm sorry, how many participants are we expecting?
More than 100, like 100
Okay.
plus, I think.
Do we have Zoom space to accommodate everyone?
Yeah, yeah, yeah. We'll accommodate around 100 people, and then rest of them can join through YouTube Live.
Okay, sure.
Thank you.
Thank you. Hi, can we start? Or are we waiting on someone?
Yes, sir, we can start in a minute. I was waiting for more participants to join in.
Okay, sure.
Um,
I'll just
just
share my
one
screen by
minute.
then if that's okay.
Yeah, yeah, sure, you can. Surely
Yeah.
do that.
Cool.
मम्मा एक सेकंड सुनो तो एक क्लचर दो तो एक क्लचर या कुछ भी पेन दे दो हेलो हेलो
Yes, hi, you're audible. Yeah, I just want to confirm if my screen is visible.
yes sir, your screen is visible. We'll just start.
Perfect. Thanks for the prompt. I'll just put it on slideshow. Just a second. Yeah.
So is my camera visible?
No, I don't see anyone except myself on screen.
Okay, just a second, just a second. Good afternoon, everyone, and thank you for joining. I welcome you all to this free workshop on enforcement of ADR settlements in India, powered by LEDX, where legal education meets technology. We recognize the importance of knowledge, education, and employment. LEDX is an innovative legal education venture that bridges the gap between legal learning and the profession. Backed by years of experience, we bring certified expertise to every corner of the country. So, moving further, I would like to welcome Advocate Tejas Hinder, an expert in ADR and enforcement proceedings. Mr. Hinder brings a wealth of experience and passion for legal excellence to our workshop today. With a distinguished academic background and prolific contributions to legal scholarship, he's here to share invaluable insights with us. Thank you so much for joining us today. Sir, can we start with the session?
Sure, perfect. Thank you.
Thank you.
Thank you, LEDX. A very good afternoon. I am Tejas Hinder. I work as a legal associate at Cyril Amachan Mangaldas, and I also work as an advocate at the Karnataka High Court. It's a pleasure to have over 80 people joining in on a Sunday. And I'm very sorry to take over your Sunday afternoon, but I think the legal fraternity is all about staying on your toes 24/7. So, the purpose of this session is to look at three fundamental aspects, which would be first, arbitral awards and their enforcement, which we have quite a lot of jurisprudence and a statutory basis on. Second, we will look at mediation settlements and agreements, basis the AFCON's judgment and other major significant rulings, as well as Section 89 of the Code of Civil Procedure, coupled with the recent Mediation Act of 2023. And then we will look at conciliation-based settlements, um, basis which we will look at the Arbitration and Conciliation Act again. And in addition to that, of course, we do have negotiations that do happen informally, but that's something we would only be looking at from the perspective of compoundable offenses as and when needed. So that's not something that will be included under the scope of this workshop. In addition to that, of course, collaborative law is not something that has received legal enforcement in India. So we will not be looking at collaborative law as well as part of the scope of this session. While I do understand I see a message saying no audio, so please check. Am I not audible?
You are, sir, you are audible.
Oh, okay, cool. Thank you for the confirmation. Right. So coming back to what I was saying, since we do have an hour, let's structure it this way where we'll go through each aspect. And as and when queries keep coming in, please drop them in the chat and we shall address them in the last 10 to 15 minutes of the session. And we can, of course, extend the session as and how and when convenient, provided we are like to whatever extent we are permitted to extend it. So without further ado, let's look at what and how arbitral awards are, how and what arbitral awards are, and how are they looked at. So, as we know, the Arbitration and Conciliation Act is something that continues to unfold new dimensions with every scrutiny that comes across, be it the 2015 amendment, the 2018, 2019, 2021, 2022, or the 2023 amendments. So the act is akin to a profound scripture which has revealed itself in layers, which has given new interpretations, insights, and indeed paradoxes with each revealing. And it is for us, it is intriguing to note that the effectiveness of any dispute resolution mechanism is critically placed in the robustness of its enforcement capabilities. And according to the Act, an arbitral award is to be enforced in line with the provisions of the Code of Civil Procedure, mirroring the treatment of a court's decree. So once we venture into the realm of litigation in India, uh, we look at a Privy Council observation that has been looked at time and again by courts in India, most notably, as you can see on screen in point number 4, in the Satyavati versus Rajendra Singh case as well, followed by it being looked at in the Rahul S. Shah case as well, respectively in 2013 and 2016 for Satyavati and 2021 for Rahul S. Shah. So what it says is that there is a capturing of the enduring struggles that is faced by decree holders, and it is a scenario that remains unchanged even 150 years later. So the Supreme Court of India has repeatedly expressed its dismay over the ensuing challenges in the execution phase. And in the 2016 judgment of Satyavati versus Rajendra Singh, it has highlighted the systematic delays that prevent decree holders from enjoying any sort of prospective victory that comes across. And it's the problem still exists even after a favorable ruling that came across in 2016. So, in response to these delays, in 2021, in the Rahul Shah versus Jitendra Kumar Gandhi case, there was an attempt made to expedite the execution process by mandating disposal of execution proceedings within 6 months from their filing. And this directive aimed at alleviating the judiciary's burden, and it underscored a persistent quest for efficiency. And yet, the real world impact of these measures on the overburdened judiciary seems to be a subject that is still being discussed, which is why we're in one workshop like today. So, where does the Arbitration Act come into play and what does it provide? So, the narrative of enforcing arbitral awards under the 1996 Act complicates the landscape. So, because post the award issuance, a waiting period of 3 months, extendable by 30 days, is mandated for any potential challenges under Section 34 of the Arbitration and Conciliation Act. And the procedural interlude culminates in the award's finality, and it ironically leads the award holder back to the judiciary, the very entity that was sought to be bypassed through arbitration in the first place. So the procedural paradox highlights a significant gap in the Act's intent to offer a swift dispute resolution alternative. So where does the execution conundrum then arise? The execution of decrees, as governed by Order 21, as you all may be aware of the Code of Civil Procedure, presents a convoluted battlefield in my understanding because of the rife with procedural intricacies. The extensive rules therein open floodgates to delay tactics by judgment debtors, and it is further made worse by the judiciary's prioritization of petitions and suits over decree execution, as we have seen in practice. And this systemic irony was starkly highlighted in a case which we look at today as the Delhi Airport Metro Express Private Limited case, which is the case of Delhi Airport Metro Express Private Limited versus Delhi Metro Rail Corporation Limited, where the Supreme Court lamented India's aspirations to become an international arbitration hub against the backdrop of unenforced arbitration awards. So, what can then be done is a big question before we delve into any procedural intricacies that we shall be going about for the purposes of this workshop. So, the Supreme Court's call for a more efficient disposal of execution petitions echoes the broader necessity for procedural and legislative reforms. And the formation of a committee by the government of India to suggest reforms is something that has happened time and again. But the reform must transcend into robust legislative amendments to encompass a procedural overhaul for the swift enforcement of arbitral awards. So, what exactly, I'm sorry, how exactly do we see this process placed today? So, we can understand enforcement of arbitral awards on two parameters. First, there is an award. First, there is an enforcement of domestic awards. Second, there is enforcement of foreign awards. So an award holder would have to wait for a period of 3 months after the receipt of the award prior to applying for enforcement and execution. I think I even saw a question in the chat box for the time limit from Arth Shah. I think this point, as we discussed, like hits that, right? So you need to wait for 3 months prior, after the receipt of the award prior to applying for enforcement. And during the intervening period, the award may be challenged in accordance with Section 34 of the Act. And after expiry of this period, if a court finds the award to be enforceable at the stage of execution, there can be no further challenge as to the validity of the arbitral award. So if before the 2015 amendment, and if an application was made for setting aside an award, it would tantamount to a stay on proceedings for execution of the award. And by virtue of the 2015 amendment, now a party which makes a challenge to an award would have to move a separate application in order to seek a stay on the execution of the award. So let's now understand enforcement of foreign awards. So as all of you may be aware, foreign awards are executed basis the New York Convention, which is the Convention on Recognition and Enforcement of Foreign Arbitral Awards of 1958. As well as we have the Geneva Convention of 1927, which is the Geneva Convention on Execution of Foreign Arbitral Awards. So basis the same, if a party receives a binding award from a country, which is a signatory to the New York Convention or the Geneva Convention, and the award is made in a territory which has been notified as a convention country by India, the award would then be enforceable in India. And the enforcement of a foreign award in India is a two-stage process, and it works by initiation by filing an execution petition, and then a court would determine whether the award adhered to the requirements of the 1996 Act. And once the award is found to be enforceable, it may be enforced like a decree of that of the court. But at this stage, parties would have to be mindful that certain challenges would arise, such as maybe objections that the other side would take, that is the other party, and requirements such as filing original or authenticated copies of the award and the underlying statement before the court. I'm sorry, I correct myself. We also have the PASL case that came across versus GE earlier, amidst the pandemic, which again reinforced the position that foreign awards would be enforceable in India. So what are the requirements then? So there are three fundamental requirements as we can understand, after which we will look at Section 47 of the Arbitration and Conciliation Act. So the first is that the original award or a duly authenticated copy must be made in the manner required by the country where it is made. Second, the original agreement or duly certified copy should be there in place. And third, evidence necessary to prove that the award is a foreign award should be provided wherever possible. If we look at the wording of Section 47 of the Arbitration and Conciliation Act, the word shall is used, and it says shall be produced before the court at the time of application. But this word has been interpreted by the Supreme Court very recently in the case of Ostbulk Shipping in 2018. And it said that the word shall appearing in Section 47 in relation to production of evidence for the third parameter, that is evidence necessary to prove that the award is a foreign award wherever applicable, may be read as may and not shall. So it further observed that that interpretation would mean that a party applying for the enforcement of the award need not necessarily produce before the court a document mentioned therein at the time of application. But it also clarified that the interpretation of shall as may, which was misconceived by a lot of people in the legal field to be optional as opposed to mandatory, it clarified that that option is provided only to the initial stage of filing the application and not thereafter. And additionally, there was another landmark judgment in 2001, which was that of Fjost de Lawson Limited versus Jindal Export Limited. It was of the Supreme Court as well, wherein it was clarified that for enforcement of a foreign award, there is no need to initiate separate proceedings for recognition and subsequent execution. So, what are the conditions that come across then? So, there are, like, to put it down summarily in pointers for easy reference. First, we need to prove that, of course, the parties to the agreement were under some incapacity. Second, it can be proved that the agreement in question was not in accordance with the law to which the parties have subjected it to, or under the law of the country where the award was made. So this takes us back to how arbitration agreements, I'm sorry, this particular point, I correct myself, takes us back to how an arbitration agreement was drafted. So basis what has been decided as the applicable law, wide party autonomy, or basis what has been decided by the parties to be the lex seatus, or the basis deciding the seat of arbitration. If there is an award made in non-compliance with such law, then of course enforcement, a request for enforcement or an application for enforcement can be set aside by the court. Third, if there is a failure to give proper notice of appointment of arbitrator or arbitral proceedings, or the party against whom the award was rendered was otherwise unable to present their case. Fourth, if the arbitral award that is issued goes against the agreement or the submissions made, that is, if it falls outside the scope, or if it is assuming legal considerations, it may be set aside. Fifth, if the award contains decisions on matters beyond the scope of submission to the arbitration, which flows from the previous point. Sixth, if the composition of the arbitral authority or arbitral procedure is ultra vires the agreement, which basically means that in case parties had decided to have a specific number of arbitrators to be part of the arbitral panel, and the same is in accordance with law, if the same number of arbitrators of the same arbitrators were not appointed, or if there are maybe restrictions or considerations as to nationality and qualification, and if that is stipulated in the arbitration agreement and that has not been adhered to, even then an application for enforcement can be set aside. The composition of the arbitral authority or the arbitral procedure, if that is not in accordance with the law of the country where the arbitration took place, which is where, like, don't confuse this to be the venue. When it says I mean this to be the seat, the law and the law applicable thereunder, if the composition of the arbitral authority is not in accordance with the same. That is, for example, if we push ourselves back to 2019, there was a judgment of Perkins Eastman Architecture versus DPCC, wherein the appointment of sole arbitrator under the appointment of a sole arbitrator or a single arbitrator was to be regarded as not valid under Indian arbitration laws. But even, of course, that judicial position got overruled. But if we were to get back to 2019 and there was a sole arbitrator appointed for an arbitration seated in India, and with its venue not being in India, then of course it is something that would violate the Indian arbitration laws, as a result of which an application for enforcement would be set aside. Then the award, if the award has not yet become binding on the parties, or it has been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. And then we have two more considerations which are paramount. First, if there is an arbitration most particularly seated in India, if the subject matter of the dispute is not capable of settlement by arbitration under Indian law. So, like to give you an example for this point, in Indian law, we know for a fact that issues that are concerning right in personam are arbitrable. That is, if there is an issue to which the relief that would be provided is specific in nature, that is to like to a specific set of people, then of course it is a question of right in personam, and and the dispute is arbitrable. So then that consideration, yes, the subject matter is arbitrable. However, if it is a question of right in rem, that is maybe any crime that has been committed, any felony that has been committed, or anything where the nature of relief pertains to the public at large, then of course such disputes are not arbitrable, and hence those disputes are not capable of being arbitrated in India, and they're not capable of settlement, and hence the subject matter in itself cannot be arbitrated in India. So if any award is rendered in furtherance of the same, then such an award cannot be enforced. The second is if the award enforcement is contrary. So you have to the public policy of India. So of course you have loads of jurisprudence on this. It all started back in Renu Sagar, which is not a good position in law anymore. It then came up to Sanyog Engineering and Construction Company Limited in 2019, and coming up to 2020, it was the judgment of Vijay Karya as well, both of which were Supreme Court judgments, which clarified that if there is something that goes against the public policy of India, that is not something that is acceptable to what exactly caters to public policy, or to what is regarded under the three parameters that it provided to be considered to be fulfilled for the purposes of public policy, then the award would not be enforced. So for an award, if it conflicts also, there are certain exceptions basis the Arbitration and Conciliation Act. So if the foreign award conflicts with the public policy of India, uh, then such parameters would be regarded, would be regarded to be fulfilled. I did mention to you, right, that there were three parameters that came across. So that foreign award can conflict with the public policy of India under three considerations. Those three considerations for your reference are: first, if the award was induced or affected by fraud or corruption; second, if it contravened fundamental policy of Indian law; and third, if it conflicted with basic notions of morality or justice. So the test as to whether there was a contravention with the fundamental policy, because it's vaguely worded, right? We don't have a definitive meaning. Like, we understand what fraud and corruption is, and to a fair extent, we can understand what morality and justice is. But we can't understand what fundamental policy is, because that in itself is as broad as public policy in itself. So what the court then said is that the test as to whether there is a contravention with fundamental policy of Indian law shall not entail a review on the merits of the dispute, and it went on to look at what the public perception would look like and how was the Indian society ingrained in consideration, and then the award's enforcement question would be adjudicated upon. And also to note, a domestic award arising out of arbitrations other than international commercial arbitrations, of course, can also be set aside by the court if the court is to find that the award is problematic because of it being patently illegal, and that patent illegality appears on the face of the award. And that patent illegality can be, violation of public policy. It can be in violation of any substantive laws of India. It can be fundamental violations of the Arbitration and Conciliation Act, which would be the applicable act. However, to note, a domestic award cannot be set aside merely on the ground of an erroneous application of law, or by calling forward evidence again, which in law we call reappreciation of evidence. And of course, all of the awards have stamping requirements, and those stamping requirements are basis the Indian Stamp Act 1899. And the Supreme Court, for the purposes of domestic awards, has observed that the requirement of stamping an award and registration is within the ambit of Section 34 of the Arbitration and Conciliation Act and Section 47 of the Code of Civil Procedure. And if you want to note the judgment, I'm sorry, this is not something that's there on the slide, but if those of you who are practicing, you would be aware, it is the judgment of Anasuya Devi versus Manik Reddy and others, or M. Anasuya Devi versus M. Manik Reddy and others. It was a Supreme Court judgment of 2003. And the quantum, like I think some of you will have a question in mind that how much of stamp duty will have to be paid for stamping of a domestic award. So the quantum of stamp duty to be paid would vary from state to state, depending on where the award is made. And like in my limited experience of the profession so far, I'm aware that under the Maharashtra Stamp Act, the stamp duty for arbitral awards stands at 500 rupees. And in case of Delhi, it is calculated at 0.1% of the property to which the award is in relation to, or the cost in which the award is in relation to. And as for foreign awards, I think again a judgment that some of you practicing would be aware of. The case of Shriram EPC Limited versus Ryoglass Solar SA. It is a 2018 judgment of the Supreme Court, and this was the first instance where the Supreme Court came forward and clarified that as far as foreign awards are concerned, the Supreme Court has categorically, I mean, it held that the award is not liable to be stamped. And the Delhi High Court also had a ruling in the Naval Gent Maritime Limited case, and it had observed that the foreign award would not require registration and it cannot be enforced as a decree. And the issue of stamp duty cannot stand in the way of deciding whether the award is enforceable or not. And this was taken into consideration, notably in the PASL case that subsequently came out, which allowed for enforcement and execution of foreign awards in India. And a similar approach was also adopted by the Bombay High Court, just for your reference. It was the Vitol SA versus Bhatia International Limited. I'm sure it's a very famous case. All of you must be aware of it. I mean, it basically echoed what the Delhi High Court said, and said that it for an award would not require registration and can be enforced as a decree without the same. And the issue of stamp duty cannot come in the way of deciding whether the award is enforceable or not. I think the most specific concrete jurisprudence which answered what the Supreme Court did not answer back in 2018 in the Shriram EPC Limited case came across in PASL. So now we know for a fact that stamping is not a concern, execution can happen, and registration is not a mandate as far as foreign awards are concerned. And for your understanding, there are quick know-hows with regard to enforcement of awards that I'd like to briefly bring to your notice before we jump on to mediation. So I think one is, what is the time frame for for a tribunal to interpret an award on its own initiative upon request by parties before the 3-month period in front of the court? So just to answer that, an arbitral tribunal is empowered to correct any clerical, typographical, or maybe computational errors on its own if a party makes a request basis Section 33 of the Arbitration and Conciliation Act. Within, and the same request has to be made by parties in 30 days. So parties have 30 days from the date of receipt of the award to request for such corrections. And the tribunal has a maximum limit of 30 days to make those corrections upon receiving such a request. And for your reference, the tribunal can also interpret a specific point or part of the award if requested by a party, provided there is an agreement between the parties to this effect. And such interpretations must be given again within 30 days from receiving the request. I'm sorry, my presentation is stopped. Just give me a minute. Yeah. So how can awards be challenged and then be set aside? So a domestic award can be challenged in India by filing an application under Section 34 of the Act to a competent court. And again, this must be done within 3 months of receiving the award, extendable by a further 30 days if you have sufficient cause. So what does sufficient cause mean? If you're able to demonstrate to the court that you had some issues in filing, and these are not personal issues that you can highlight before the court, of course. If there was any consideration that you wanted to give the tribunal, the 30 days consideration that we just spoke about, if there was non-cooperation from the other side, if there was a delay in receipt of the soft copy of the arbitral award, if there were procedural irregularities before the court, if the court in itself was not operational for a certain period of time due to some issue, or on certain days because of some strike or anything, those are issues that you can show as part of sufficient cause. And I think most of you dealing with procedural law as practitioners must be aware of this. Uh, and the challenges can be based on the grounds listed in sections 34(2)(a) and 34(2)(b). And to broadly place these before you, these include incapacity that we all discussed already, incapacity, invalidity of the arbitration agreement, inadequate notice of the arbitration proceedings, awards beyond scope of arbitration, improper tribunal composition or procedure, or the awards going against public policy. Then at what levels of appeal and costs, at what levels of appeal costs can be considered to be involved? So first thing you need to understand is that the challenge under section 34 is not considered as an appeal, but an appeal against a decision under section 34 can be made under section 37 of the act, and a further appeal is possible to the Supreme Court under article 136 of the Constitution of India. So the resolution of a section 34 challenge should ideally occur within 1 year, with appeals under section 37 potentially taking from 6 months to 3 years. And it's subject to, like, I mean, of course, the 6 months to 3 years is subject to how complex the award is or how big the award is. And the costs would include, if anyone wishes to go as a client or anyone wishes to consider this as a counsel, fees and court fees, with parties generally bearing their own costs unless the court finds the challenge to be frivolous. Recognition and enforcement, we've looked at it basis 36 and 47. And yeah, of course, limitation. So if there is a limitation period that is sought to be enforced, we look at the judgment of Union of India versus Vedanta Limited. And this judgment clearly lays down that the limitation period for enforcing domestic awards is 12 years, while for foreign awards, it is 3 years from when the right to enforce accrues. And I think two final points of consideration. If the enforcement of foreign awards can be annulled at the place of arbitration. And just to know that in this regard, like we've looked at in the past, Indian courts will generally not enforce a foreign award if it has been annulled at the place of arbitration, reflecting a cautious approach towards the enforcement of such awards. In addition to that, if you look at something like emergency arbitration and its enforcement, we recently had the Amazon.com case, that is the Amazon.com NB versus Future Retail Limited case, which recognized the enforceability of emergency arbitration orders aligning with international arbitration practices. And if you want to look at costs of enforcement, you have enforcement involving legal fees, including attorney and court fees, and it is typically borne by the parties, unless the court orders otherwise due to the frivolous nature of the challenge, that is, if the nature of challenge is pointless or meaningless. Yes, we now move to mediation, that is mediation, settlements and agreements. So mediation, as you all know, is an out-of-court settlement, to word it broadly, wherein two parties sit across in the presence of a third-party intermediary. It is not in any way not adversarial, and submissions are not made to any neutral third party. Instead, in the presence of a neutral third party, discourses happen and discourses are made. So mediation, again, serves as a key alternative dispute resolution mechanism, sometimes preferred over arbitration because of direct contact between parties, in the presence of someone who can handle heated situations, present in the form of a third party, I mean, a neutral third party who doesn't involve themselves in a dispute, or who doesn't take significant steps to decide, which is, I think, slightly possible. Of course, it is not, slightly possible in conciliation, but of course, even in a conciliation, the conciliator can't decide for the parties, but they can place specific leading questions as opposed to mediation, right? And the Supreme Court of India, as you can see on the screen as well, in 2014, in the case of Vikram Bakshi versus Sonia Khosla, highlighted the benefits of mediation, emphasizing its role in creating a favorable setting for parties to reach out to mutually beneficial outcomes. So mediation not only aims to decrease the backlog of cases, but also seeks to shift the, if we can understand it correctly, the legal paradigm from adjudication to dispute resolution. So despite its advantages, mediation in India is still developing, and it is hindered by the absence of a dedicated mediation statute till, of course, the 2023 Act came into place. And of course, but despite the same, there are several procedural uncertainties that still exist, which I will be addressing. Um, so mediation settlements or mediation settlement agreements, they come across as legally binding contracts that are formulated post mediation, and they encapsulate the terms agreed upon by the parties. So typically, these agreements will be crafted by the third party neutral, and they will be crafted voluntarily and jointly, and they do not necessitate judicial intervention, uh, like any court interference for that matter, for validation, and are formalized through signatures in the presence of mediators and legal representatives. However, what does happen off late, like you see certain high courts like Karnataka, where I practice, has this mandate that for family disputes, except cases as grave as maybe dowry death, or property disputes, except property disputes where some element of crime is accompanied with, and there is a question that arises because of there is a question that arises pertinent to the involvement of criminal laws or penal statutes. They always mandatorily first refer to mediation. So mediation is often preferred in family and divorce law due to its cost efficiency and adaptability. Um, the significance, in my understanding of mediation settlement agreements, lies in their capacity to convert potential risks and delays into decisive actions by the parties. And what does it do? It fosters clarity and reduces legal and court related burdens. It ensures that the agreements are documented in writing, and the conclusion of successful mediations is crucial for such implementation, of course. And the confidentiality inherent in mediation again underscores the importance of formalizing the agreement's key terms to facilitate proof of consensus and enforceability. And what does it do? It avoids post mediation reconsideration by the parties. So, till the 2023 Act, the legal framework in India did not explicitly define mediation, and it had references to in contexts such of commercial disputes governed by the of course the Code of Civil Procedure and the Commercial Courts Act of 2015. So till the 2023 Act came into play, Section 89 of the Code enabled courts to direct disputes towards out of court resolutions, including mediation, through this provision. And though this provision required judicial consideration of settlement terms, which potentially again complicated the process. Like we discussed during arbitration, that after an award, you again go back to a court to enforce it. So this judicial intervention, even for a mediation settlement, basis Section 89, looked like it would destroy the process. And court annexed mediations, like we discussed the position of Karnataka, uh, court annexed mediations would also have settlements, and those settlements would gain enforceability through court orders, and that would conflict with private mediation, where agreements lack the same legal weight as arbitral awards, and the enforceability challenge arose. So by private mediations, of course, parties can have issues if they have mediation referred to as a step as part of a dispute settlement clause or a dispute resolution clause in any commercial contract or commercial agreement. Parties would again have an issue if they referred their dispute primarily to mediation itself, maybe outside, to a mediation center that is privately in place, like internationally speaking, SIMI, Singapore International Mediation Institute, and domestically speaking, something like the Asia Pacific Center for Arbitration and Mediation, or we have the IIM, Indian Institute of Arbitration and Mediation, to name a few. So if these references were then made, then their enforcement became a big question mark. And then the enforceability challenges were not present consolidatedly till we had this case of Ravi Agarwal versus Anil Jagota, wherein the court stated the court had declined to enforce a private mediation agreement under specific provisions of the Arbitration and Conciliation Act. It said that the Arbitration and Conciliation Act is limited in scope to arbitration and conciliation settlements as opposed to mediation. And the Commercial Courts Act and the amendments like what we had in 2023 now seek to bolster mediation by equating certain mediated agreements with arbitral awards. And the emphasis on the need of a written and signed agreement to ensure that they legally stand. But what still remains now an issue, despite the Mediation Act 2023, is the enforceability of verbal agreements, which reflects a broader challenge. So now, if there is a consideration to be made, what people say is that most mediation proceedings, even though they happen in camera, for judicial perusal, they can happen within, they can be recorded, and those recordings can be placed in case a question of enforcement is to arise. So and then what we can then say in conclusion is while mediation offers to be something that is promising, the enforceability is still an issue, particularly the absence of a comprehensive legislation to address these challenges of verbal agreements and what to treat these mediation agreements akin to for the purposes of enforcement. But of course, we can credit the Mediation Act of 2023, and it marks a pivotal step towards addressing these challenges. As what it does is it attempts to underscore the importance of written agreements for legal validity and provides for possible treatment of mediated agreements robustly written as good as arbitral awards to be enforced in a similar fashion. But yes, of course, there is still a long way to go if I could put it in a broad and sanguine note. We now come to conciliation. So I think the first question that would arise is how do mediation and conciliation primarily differ? So of course, in a mediation, you just meet and you discuss. And in conciliation, you have submissions that are made in written in advance to a conciliation officer. And conciliation is, of course, statutorily regulated and governed under the Arbitration and Conciliation Act 1996. And in addition to that, the conciliator will not have, I think, judiciary at the state and central level has time and again clarified that a conciliation officer cannot mandate or force settlements. Instead, what it can do is it can make an attempt to provide for specific leading questions that can lead to an intersection and possible agreement. So how do we look at a conciliation settlement? So conciliation settlements are most commonly seen in, if you can say, labor disputes, where the labor commissioner or the deputy or assistant labor commissioners come and act as conciliators. Conciliations are also made possible in high-stake commercial disputes. So then, the ability to contest a conciliation settlement is similar to challenging an arbitral award made by an arbitral tribunal under Section 30 of the Arbitration and Conciliation Act. And it treats the conciliation statement under the Act, the treatment offered to the conciliation statements under the Act is as if it were an arbitral decision on agreed terms related to the dispute. So according to Section 36 of the Arbitration and Conciliation Act, an arbitral award is to be executed as per the Code of Civil Procedure 1908, and it is akin to a court decree. And once the period to appeal against the award under Section 34 has lapsed, or such an appeal has been rejected, that period will begin. And practically, in my understanding and areas of experience, there is no clear provision that exempts an arbitral award on agreed terms from being contested, suggesting that Section 36 applies to all types of arbitral awards, including those based on agreement. And what is then required is a question that everyone would have. So then a request to enforce such an arbitral award cannot proceed until the appeal period against Section 34, which is that of 3 months, has ended. And this opens the possibility for an arbitral award, now a conciliation statement, settlement, to be challenged. And the absence for this specific exclusion for arbitral awards on agreed terms in Section 34 would support a contention that a conciliation statement viewed legally as an arbitral award is to be viewed legally as an arbitral award on agreed terms could be subject to a challenge under Section 34 of the Arbitration and Conciliation Act of 1996. So accepting such a challenge could significantly undermine the the effectiveness associated with enforcement, to word it better, of a conciliation statement or a conciliation settlement or a conciliation settlement agreement. And then it just diminishes the value of conciliation as a dispute resolution method. So what then stands as an alternative, right? Uh, in my understanding, an alternative interpretation could provide for a solution by maintaining that although a conciliation settlement is considered as an arbitral award, the Act does not enforce the courts or does not force the courts to to treat conciliation as arbitration or a conciliation or a conciliator as an arbitral tribunal. And challenges would therefore be limited to specific grounds such as party failure or the award's contradiction to public policy. And it narrows the scope for contesting such conciliation settlements. And a further resolution could involve amending the Arbitration and Conciliation Act to explicitly state in Section 36 that we discussed that a conciliation statement, or a settlement, as an as an arbitral award on agreed terms should be immediately enforceable, and the 3-month gap should be then done away with. And that would also make clear that under Section 34, there is no application thereafter to conciliation of settlements or arbitral awards on agreed terms, and then possibility of challenges could be eliminated, and the integrity and intended efficiency of the conciliation process could be safeguarded. And this change would address potential delays inherent in the conciliation process, which would impact the limitation period and remove any avenue for disputing a conciliation settlement agreement, and then provide for the intended effectiveness as a dispute resolution tool. So that's the way in which the conciliation can be sought after basis the conciliation settlements. Yes, that I think brings me to the end of the presentation. Let's look at the questions now. Someone has asked if there is any definition. I'm so sorry, just give me a minute. I'm sorry. Yeah. Excuse me. If someone is, wait, can I share the PPT after the session? Yes, I will. The time limit, I think we've discussed this, 3 months. If a country has withdrawn from treaties, will the cases before the withdrawal be continued in India? That is something that we still need to look at from a legislative position. But I think if we look at both the New York Convention and the Geneva Convention, there is right now no statutory stoppage on like finalization or culmination or conclusion of proceedings in case of withdrawal. I think all the pending proceedings would have to be disposed with, only after which withdrawal would be permitted. Then, of course, they say, can an arbitral award be set aside on the ground of public policy? If yes, in which judgment has it been held? I think we've looked at this already. Then, is there any particular definition of public policy in Supreme Court judgments? I think we've discussed the 3 parameters. What if a party did not pay full stamp duty? I mean, I don't know. I mean, it's just that the award would, I mean, if it's a foreign award, of course, there is no mandate. But if it's a domestic award, then the enforceability becomes an issue. Because, of course, there is no legal value attached to such a settlement. So its enforcement becomes like, its enforcement will be very difficult. Is there any particular time in which the stamp duty has to be paid? I think before making any, I think there's no limitation as such under the Stamp Act. But again, you'll have to see if again it's a state specific question. You will have to see the limitations under the respective state acts for I mean any set arbitration settlement agreements or conciliation settlement agreements. And but it has to be done, of course, before you look forward to enforceability. Yes, I'd seen Diksha's request asking me to go a little slower, and I attempted to do so. I hope that clarification came across. Um Application for setting aside is filed before which court? It is initially filed before the respective state high court, after which under 136 you can also move to the Supreme Court. Then there's a question that asks, sir, how arbitration and mediation plays a magnificent role via corporate law firms for settling the matter for parties outside court? What is the cost that parties has to pay? See, in my understanding, law firms in the status quo do not do mediation, and law firms only act as arbitration counsels. They don't act as arbitrators as yet. So that's, I mean, you'll have to still go to arbitration centers, or you'll have to initiate it privately, and you'll have to designate prospective arbitrators in the field basis your knowledge of who are efficient arbitrators in the field. So you can do that. But I think for now, what you just ought to understand is that yes, arbitration is quite in advent in boutique dispute resolution firms and dispute resolution teams of top tier firms. So I think you can always refer to these firms for arbitration counsel support, but not to serve as an arbitral tribunal because of client privilege and client commitments. Law firms cannot act as third party neutrals, and mediation is still really not on the onset in any of the law firms. Very basic difference between mediation, conciliation, and arbitration, along with the binding nature. All right. So binding value is something that is attached to all three settlements. And the very basic difference would be in an arbitration is more adversarial in comparison to the other two, wherein you have arbitrators appointed before whom submissions are made, and then their decision is akin to a court judgment, just that it doesn't take so long because of I mean absolutely no other pending case before such a tribunal, and they dispose it more like efficaciously, and of course they have a stipulated time limit. And I mean it's where parties don't have a dialogue. Mediation and conciliation, of course, involve parties having a dialogue in the presence of the parties, or I'm sorry, representatives of parties. I'm sorry, I correct myself, who can come to such a conclusion or a decision um, for those respective sides. But again, a conciliation would involve pre-hand submissions that are made and written to a conciliation officer or a conciliator, as opposed to a mediation where the same is not necessitated. And at the same time, a conciliation officer is a little more empowered to intervene as opposed to a mediator who is a neutral third party. Wherein specific leading questions towards settlement are encouraged. But of course, as opposed to an arbitrator, neither a mediator nor a conciliator can take decisions for the parties. Can a mediation be sent to conciliation to record agreement? No, it cannot be, Earth, because I mean, they're two different statutorily ingrained processes, and they're differently statutorily regulated. So you can't have those you can't have it moving from one settlement to another. But in case there is a dissatisfaction, you can always withdraw the case and request the court for conciliation, provided that the same comes within the scope of conciliation, which would include again labor disputes, high-stake commercial disputes, etc. If the court has sent a case of arbitration from an arbitrator to conciliation, then the settlement agreement will still be an arbitral award. See, again, this is a very far-fetched consideration that you're having, that there is an arbitration that is stopped and it goes to conciliation. Usually that's not how the law works in practice. But I mean, if such a hypothetical situation were to arise, you don't have to have you don't have to have this precondition of the arbitration being pushed to conciliation for a conciliation settlement to be treated as an arbitral award. I think the position is just to be looked at plainly from the perspective of Section 36, where the conciliation settlement will be treated as an arbitral award. If there is not an arbitration agreement, can a matter be referred before arbitration? Yes, of course, by subsequent mutual agreement, you can always refer it to an arbitration center. or you can always have a subsequent dispute resolution agreement drawn in case you don't have it pre-handed. But yeah, it's always like it's always good to have it drawn before, so that an issue does not arise before. An issue does not arise in consideration of this. I mean, in consideration of what has been agreed upon in the past, where one party would be like, no, let's just go to court and litigate it, and the other side no says no, let's arbitrate it and have more efficacious settlement. Can a party seek interim measures or stay of enforcement of an arbitral award pending appeal? You can seek, of course, you can seek a stay for not more than 30 days. But of course, you will have to back it with sufficient cause. And I think interim reliefs, you can be, an interim relief can be sought amidst the pendency of an arbitration before a court of law. But at the same time, you now have emergency arbitration provisions. An emergency arbitration mechanism that is there in place basis the Amazon case, Amazon Amazon.com NV versus Future Retail, which has allowed for, which is very considerably allowed for emergency arbitration, and the nature of relief in emergency arbitration is always an interim relief. So interim reliefs can be sought in the very arbitration itself before a final settlement is reached to. Then there's a question that is the decision of ADR equal to regular court decision, especially in family matter? Yes, it is. It can have, I think for mediation, of course, it's a little problematic. But now that the 2023 framework has come into play, and most of the settlement, most of the states now refer their family matters and property matters to ADR first, most preferably mediation. They say that any settlement that has been drawn will be capable of being enforced basis section 89 of the Code of Civil Procedure that we discussed as a, as a judgment of a court of law. Can a tenure of arbitral conciliation mediation? Okay, I think you're trying to say arbitration, mediation, and conciliation proceedings be extended. Yes, it can. For arbitration, you'll have to agree upon, provided within it is within the limits of what has been prescribed in the Arbitration and Conciliation Act 1996. It is, you can extend it by mutual agreement and by paying the extra costs. And I think the same with mediation, provided it is within the time frame that the court has prescribed or allowed, in case it's a court annex mediation, or by mutual consent between parties, in case it is something that the parties have privately initiated. And in case of conciliation, again, as permitted within the limits under the under the limits of the Arbitration and Conciliation Act. I think there's a question from Bharvi that says, per parties and dialogue part, can you say again? Yeah. So in what I meant to say is, in mediation and conciliation, parties sit across and they discuss, as opposed to arbitration, where the submissions are made to an adjudicator in the form of an arbitrator. So just make sure that you understand that the difference between mediation and conciliation then comes across in the powers and scope of such powers of the neutral third party, which is that of mediator and conciliator, where the mediator's involvement is restricted to mere, mere broad facilitation and navigation, as opposed to a conciliator who finds himself in a position to involve by placing specific leading questions and asking what's convenient and what's not, and thinking for what may be good with the parties with a specific mindset, as opposed to a mediator. What is the relevancy of affidavit made before ex-magistrate by a non-joinder party in civil suit? This falls outside the scope of the session. I'm sorry, I'm not allowed to answer this. If the judgment debtor fails to file an application for setting aside, okay, I think you're trying to say setting aside, you've written setting aside the arbitral award within 3 months duration. So would they have a recourse for filing a delay? Yes, I think we discussed this, right? You would have 30 days extra, wherein you would have to prove to them as to what caused that delay, and that there was sufficient cause for that delay. Then can retired chief justice practice as arbitrators and mediators? Yes, they can. They can definitely, retired judges for that matter can enroll themselves with government mediation centers like Delhi Mediation Center, Bangalore Mediation Center, government arbitral institutions like Delhi International Arbitration Center, and you can obviously serve there. And you can also affiliate yourself with private practice. provided you're not conflicting with your work is not conflicting with any of the public centers you would be serving under or any other private centers that you are serving under. So, what are the procedural steps involved in initiating a legal action or filing a claim and conciliation? So, this is it's not quite. I mean, it's not something that is. I mean, that is rocket science. You just it's very simply an application has to be filed before. I mean, when in amidst the pendency of a dispute, for the dispute to be referred to conciliation, and this does not happen at a high court level. This happens at the district levels or like in front of either a civil court or the commercial civil court or in front of the labor court or the labor tribunal for that matter, from where it can directly be referred to conciliation considering the nature of dispute. And uh, and then once it is mandated, submissions are to be made to the conciliation officer. You do not have to wait for the dispute to be elevated, or you do not have to, and this cannot be, of course, filed before the very dispute is started. Okay, so there's a question from Kaustav Bhattacharya. If there's no dispute resolution clause in an agreement between parties, but if they had multiple previous agreements with if they had multiple previous agreements with dispute resolution clause that had arbitration as a means of dispute resolution, may the same be read into this agreement? See, that's only possible if there is something, I mean, if there is a collateral element between both between these agreements that are there in place, that is the agreement that is considered that contains the dispute resolution clause and the agreement that does not contain the dispute resolution clause. And in case there is a collateralism that is exhibited, and at the same time there is an initiation of arbitration by showing that the claim that is being raised is basis this agreement that has the dispute resolution clause, only then would the terms and conditions of arbitration under uh, the terms and conditions of arbitration under the previous agreement, which has a dispute resolution clause, be taken into consideration. But for that, I mean, it has to be flown into basis the previous agreement. But at the same time, if there are two separate agreements, and at the same time there are questions being raised, or if the claims are being raised basis the agreement under which the dispute resolution clause is absent, then the same cannot be read into. However, if it is sufficiently demonstrated before the court that there is a reference or there is a relation that is in existence, and the past dispute resolution clause in some way makes a reference or has consideration to include the scope of the new agreement, which does not have a dispute resolution clause, or in some way has the new agreement without a dispute resolution clause annexed to the previous agreement, only then can this be raised, or only then can this reference be made. But and this reading into can happen. In India, how is third party funding in arbitration allowed? I think that's a very long answer. I will drop my email ID to you. You can reach out to me. But I think to put it very briefly, in case there is no direct conflict with the arbitral institution that is that has been set up, or the arbitral tribunal that is set up, or in case there is no third party funding from someone who conflicts with the dispute, or from someone or from someone who is not in conflict with the party against whom a party being funded is placed, can third party funding happen? And its limits are restricted to that of the costs and the cost estimate. Actually, the cost estimate is too premature to call it costs. The costs that are decided, and the cost as prospective cost estimate of the arbitration. We now see two questions from Nalin. Can mediation proceedings be done in case of divorce matters? If yes, then would it be binding on parties? Yes, it would be. And the enforceability in case of a private mediation comes basis the 2023 Act. The second question is, whatsoever the mediator would be adjudicating, do the parties have some course of redressal against it? So the mediator never adjudicates. The mediator is just an intermediary who sits and facilitates the discussion. And if there is a settlement agreement drawn and that is dissatisfactory, you can always go to a court if it is court mandated, and you can say that, or in case there is a private settlement being enforced, you can always show that that is something that you were not in agreement to, placing sufficient records in place, and it's something that has gone against your interest. But I think to wait for that, mediation is a voluntary process. So you can always choose to withdraw from the proceedings, or let the mediator know that it's not going the way you expected it to go, and the way you the way you it's not going as per the mindset you opted to go for it with while it is in process. Fiza has a question. If an arbitration clause in certain partnership deeds do not have the specific dispute related to clause, for example, post-retirement settlement clause, can arbitrator, if an arbitration clause in certain partnership deeds do not have the specific dispute related clause, for example, post-retirement settlement clause, okay, can it be arbitrated as what I understand? Can jurisdiction be valid? Only in case of a certain addendum that has been made or a certain amendment through the means in which parties have agreed to amend the agreement. And in case of absence of an amendment provision, the way in which it has been mandated under law and it is, been mutually agreed upon is followed, only then can have uh, such an arbitral tribunal have the jurisdiction to actually consider itself capable to arbitrate. Can minor claiming the property be okay? Can the minor claiming in the property be mediated by the guardian? No, it can't be, because a mediator cannot have a conflict of interest or a direct involvement in the dispute. And I think there is a conflict of interest uh, if the guardian is related to the minor, then of course there is a conflict of interest, so they can't be mediators. The last question you taught us, in the case of foreign arbitral award, if stamp duty is not paid, then also it is not enforceable. I think you have understood it wrong, Nalin. Um Foreign arbitral awards do not have a mandated stamp duty. Domestic awards have a mandated stamp duty. Foreign arbitral awards do not have a stamp mandated stamp duty. So if in case of a domestic arbitral award, in case there is no stamp duty paid, then of course it's not enforceable, but there is no mandate to pay such a thing. I think you've misunderstood it, Nalin. Once I share the PPT, I think it will better help clarify your understanding. And I think because there were multiple questions that were raised uh, before, like time and again, with regard to the public policy pointers, even after the session, I'll just reiterate it because I think three questions ask the same thing. So the first is that if the making of the award was induced or affected by fraud or corruption. The second is if it is in contravention with the fundamental public policy of Indian law. And third, if it is in conflict with the most basic notions of morality and justice. And like to understand, like as I mentioned, the word fundamental policy seems to be broad. So the test as to whether something is in contravention with fundamental policy of Indian law shall not entail a review on the merits of the dispute. Uh, there's one more question. What all reasons can be taken into consideration while setting aside the arbitral award? I think I had just mentioned that. I mean, in the last bit of my arbitration, but okay, for your better understanding, I will reiterate it. So the conditions are laid down in sections 34.2 and 34.2A and 34.2B of the Arbitration and Conciliation Act. And to place them, it's first incapacity of the dispute to be arbitrated or parties to arbitrate. Second, the invalidity of the arbitration agreement. Third, inadequate notice of the arbitration proceedings. Fourth, awards beyond the scope of arbitration. Fifth, improper tribunal composition or procedure. Sixth, awards being against the public policy of India. And I have just mentioned as to what the public policy pointers are. No problem. I'm happy to answer your questions. I think there are no other questions in chat. Over to you, Ledex.
Yes, sir. I think we can conclude the session. If there is any other questions that you want to ask, you can drop down it in the chat box. And if there are no questions, then we can wrap off with the session.
I have briefly answered the third party funding question, but I had requested them to reach out to me on email for a detailed answer
Yeah,
because
yeah,
it's going to
yeah.
take some
That
time.
works.
So
That
I'm just
works.
dropping my email. If you have
Yes,
any
sir.
queries, you can reach out there.
Sir has already dropped in his email. If anybody has any questions, they can revert him back on the email. I think there are no more questions, sir. We can conclude. So, as we have reached the end of today's incredible session, but before we conclude, I would like to extend a big thank you to our guest speaker for enlightening us and adding significant value to our event. Thank you so much, sir. To all our participants, thank you for your enthusiastic participation and zeal to learn. And for those who have not yet enrolled for the certificate and want to get the certificate, recording of the session, and reading material of this workshop, you can enroll for the same by just paying rupees 99. And I will share the link of the same in the chat box. Also, thank you so much for being a part of this workshop, and stay connected with us as we will be coming up with more such sessions very soon. And I'll just share the link of the page through which you can enroll for the certificate and reading material. So there was a request that can we share the PPT that you were already
Sure,
sharing?
sure, I'll do that. I think
So
I
you
have I'm in
can,
touch with Abhiratna on WhatsApp.
yeah,
I'll
yeah,
drop
yeah,
it to him
sure.
there and he'll share it further.
Okay. So you all can pay 99 rupees, and through which you can get the presentation and the reading material and a certificate
Just a
along with it.
request, I'm so sorry. If in case
Yeah,
it
yeah.
doesn't demotivate your initiative, the presentation is something that I will be sending across. So the reading material and everything I understand is something that you give from your
Yeah,
end.
yeah, yeah.
So
Sure, sure,
can the
sure.
presentation be circulated free of cost? Please don't expect
Sure,
them to
sir.
pay for that. Yeah,
Yeah,
thanks.
yeah. Thank you.
Thank you, everyone. Have a good day.
Thank you so much, sir. Thank you. If there's any questions, please let me know, or else you can also join us on our WhatsApp group. We'll be sharing further details over there.
Please, the WhatsApp group number.
Yeah, I'll just share the link of the WhatsApp group. Just a second. Yes, I've shared the group link as well. You all can join the WhatsApp group and stay connected with us and get all the updates about upcoming workshops, upcoming live classes. You will be getting, if you have already paid 99 rupees, you are the certificate and the reading material and the recording of the session.
Ma'am, do not found WhatsApp group. Please provide me.
Sorry, your voice is not audible. So you are not audible. Can you come again?
Right.
So can you write it in the chat box? I shared the link through which you can pay and enroll for the certificate and the reading material. We have a group, sir. You can join this group. The recordings will be for 6 months. They will be available for 6 months. Yes, sir. You can connect. You can share your number, or I can share our number. You can connect with us, and we'll share all the courses that we have. I'll share the number. You can call on this number whenever you are free, and we can let you know all the details, as in to what all courses we have. Sure, sir. I'll ask my team to connect with you.